Next is Professor Adam Mossoff. Adam?
Thank you, Aurelian. And thank you for the invitation to speak. You can probably, for those who know me, you can hear my voice. You can hear that my voice is not normal. And because I wasn't on earlier, because I actually have COVID-19. Just got the symptoms yesterday, and I'm one of the unlucky ones who actually has symptoms. I'm unfortunately not like the millions who just get it and never know it and happily spread it around. So I have been convalescing at home. So I'm certain though that Ajan will have to send out the email afterwards saying that you've all been exposed to COVID-19 now. That's the NYU regulation. I think it's a requirement. So in line with I'm honored to be here, and of course I'm delighted always to be involved with Richard and the Classical Liberal Institute. I'm joined the Classical Liberal Institute as a co-chair along with Bill Hayden of its Technology Innovation Intellectual Property program. Very honored to work with Richard, who was my professor originally, and I was his research assistant. And since we share a common commitment to classical liberalism, I was very happy to be here. And like the others before me, I'm not doing PowerPoint slides because I follow Lord Acton's lesser known dictum that if power corrupts, PowerPoint corrupts absolutely. So So my knowledge about antitrust largely is in the area of the interface between antitrust and intellectual property. That's my lane. I try to stay in it because I'm not an antitrust scholar. Scott was very gracious in saying that that I could go, we would be interchangeable, but he's far more knowledgeable and far more an expert about these issues than I am. But I am knowledgeable about the antitrust intellectual property interface because I primarily do my work in intellectual property. And that's kind of what I wanted to talk about today in my remarks, and talk about the continuing problems at this interface, that are exemplified by, rule of law concerns and violations of due process, as exemplified in the current merger case, enforcement action by the FTC against Illumina Grail that Richard and I have been involved with, and which I will detail. Because now the basic details of what happened in this case is that Illumina is a very successful biotech company, has many patents on various groundbreaking, very innovative blood-based genetic tests for cancer, and it spun out a small company that was labeled as Grail. It retained actually an ownership stake in the company for Grail to and do the initial innovative testing and development of some additional new genetic tests, and get some patents on it. Now you might be wondering, why did Illumina do this? Well, Illumina was effectively replicating what has been the current business model in the biotech industry for the past 20 or 30 years, which is small startups that are nimble and have intellectual capital. So what they have is they have a discovery, and they get VC funding that funds their initial kind of research and development of an idea as to whether it actually is potentially realizable and commercializable in the healthcare market. And then once they've kind of gone through the first, stage or two of FDA testing, and if they've fairly got something, then they either get bought by, more often than not, they get bought. Sometimes they license, like BioNTech and Pfizer. Sometimes the smaller company licenses to the larger company, but more often than not, they get bought by. They merge with a larger company, Merck or J&J or Pfizer, because they have the commercial and commercial and labor capital to scale. So they can quickly finish the testing and get it manufactured and up and running and into the marketplace faster. So this has true efficiencies in the healthcare market, and it's why the biotech industry has kind of gravitated toward this model since the 1980s, when the Supreme Court announced that biotech innovations could be patented. So this is why Illumina basically was replicating this model by spinning out Grail so that they could be more nimble and figuring it out and doing the initial testing. And once they confirmed it, they said, okay, the mothership is calling you back home. Let's merge again. And then the FTC said, no. And the FTC actually said, no, you can't do this. This will give you monopoly power and you're on these diagnostic tests, and you're going to constrain supply, and you're going to raise prices, and it's going to harm consumers. The FTC originally filed this lawsuit in court, federal court, to stop the merger. But then I think someone internally probably reminded them of what happened with the last time they filed a major enforcement action in federal court, which was FTC versus Qualcomm. And so they then quickly withdrew their filing and took it in-house at the FTC. And of course, by taking it in-house at the FTC, they're taking it through their administrative adjudication process. And this raises all of the separation of power concerns that have been raised about administrative adjudication, with this, where you have the same entity serving as the judge, jury, and executioner. And this case has come to exemplify all of these concerns. So just as a preliminary matter, just to out of the gate, just to show you kind of some of the kind of fundamental concerns that have been raised in this case. In the middle, so the hearing began last August, and in the middle of the administrative hearing in September, that's when the FTC decides to withdraw its merger guidelines. Now, we were still working on our amicus brief at this time, and so this is one of the reasons why we were sensitive to this issue, is because we kept making references to their merger guidelines, and now we had to take that all out of the amicus brief. But could you imagine being in Article 3 court and going through a case, a case where you're being charged with violating a statute, and in the middle of the case, the court just says, we're changing the statute. So you now have to change your arguments in the middle of the court case. And so, I mean, this is just shocking. So we revised your amicus brief, and we ultimately filed it at the end of September on behalf of 23 law professors, economists, and former government officials, identifying a lot of the substantive concerns with the case and why we don't think that this is a proper enforcement action. So this was just the beginning of the odyssey that Richard and I were put through. First, our attorneys at Paul Hastings, who are our counsel of record, we said to them, well, what happens? And they said, well, there's no rules on how you file amicus briefs at the FTC. But we communicated with the secretary, and they told us just to submit it, and we should hear shortly from them. And we didn't hear anything from them for a week. And then a week later, the brief is summarily rejected by the secretary, which, I mean, it's not even docketed. It's not, so the brief goes down the memory hole. And so our attorneys have some very interesting email exchanges with the FTC secretary, where they're asking him, well, you said we could file the brief and we followed all your rules and formats for this. What happened? And they said, and eventually, the emails got very harsh from the FTC side, and we're saying, like, you didn't understand. This is entirely discretionary on our part. We don't have to accept any briefs, and so on. So our attorney said, well, our attorneys recommended to us, well, we should refile again, just to try one more time before we kind of go public about this and maybe pursue other kind of PR options. And so we filed it a second time. And this time the secretary accepted it. So at least it was put on the docket, but it wasn't yet acknowledged as a filed brief, because a week later, the FTC Complaint Counsel files a motion in opposition to our amicus brief. And the Complaint Counsel's amicus brief consists of two arguments. One, we are not parties to the lawsuit. We don't have all the information. Therefore, we should not be allowed to file an amicus brief, which, by the way, that is the definition of an amicus brief. So I mean, it was a little weird being said they're amici. They don't have an interest in litigation. They shouldn't be allowed to file an amicus brief. But and if you left it at that, that would have been a little surprising. But then the second argument was, oh, but we also think that they're all privately on the take. Illumina has been paying all of these people to comment on this case. He cited to, articles by Bill Kovacic and others who potentially, I guess, is consulting with them. So we think that this brief should be rejected because they are lying, that they are not true amicus, and that they have an interest in this case because they're paid on behalf of Illumina and Grail, which is, I mean, utterly shocking too. I mean, can you imagine? I mean, having an amicus brief filed in Article 3 court where the opposing party says you're actually on the take, just asserting that, just bald-facedly. I mean, it'd be one thing if they've actually had evidence of it, or a reason for thinking of it. So, because in our brief we say we have no connection to the parties of the case. We know we're doing this on our own choice. So then there's another week that goes by. So that, by the way, this is now a month since we filed our brief. So our brief still has not, been even, been accepted. The FTC ALJ accepted the arguments by the FTC counsel and now rejected our brief, again, summarily. So the ALJ didn't even read our brief. It was just rejected. Now, and the only evidence of our brief's existence is the fact that it got docketed by the secretary when it was submitted. But other than that, it played zero role in the case. It was not even read. Now, I'm not going out on a limb here when I say none of this would happen in an Article 3 court. None of that. And I'm not surprised that the FTC was opposed to our brief being submitted because our brief was an important contribution. We identified some serious problems and concerns with the FTC's enforcement action and trying to prevent the merger between Illumina and Grail. We, in fact, identified that they were doing many of the same things that they had attempted to do in their failed enforcement action against Qualcomm, which, by the way, as we all remember, was soundly rejected by the Ninth Circuit Court of Appeals, a circuit not necessarily known for being receptive of the type of economic arguments that Scott identified as being useful for defenses against antitrust enforcement actions. That the FTC was engaging in entirely wholesale theorized harms. They was conjecturing that, well, they'll have a lock on the market. They weren't actually engaging with the nature of the market. The fact that Illumina actually does license its patented technologies to third parties, and it never acknowledged or talked about the trade-offs and the costs and benefits of what would actually be in Illumina's interest to either not continuing to do this or not. In fact, they just asserted, well, they'll just stop doing it because they'll have a monopoly market because of their patented technologies. And in fact, my primary contribution to the brief was, pointing out that the FTC was essentially making a de facto argument that patents equal monopoly power, which we know was abrogated by the U.S. Supreme Court in Illinois Toolworks in 2006. Now, Scott says, okay, these problems might have happened, but you still get your judicial review, right? Scott just, you still get your judicial review, and even if they lose at the FTC, we will, they could still appeal to Article 3 court. And in fact, we talked about how, like, when this eventually ends up in an Article 3 court, we'll file our amicus brief at that point in time. But that's a stain that really highlights the that's true in theory but not in practice dictum, because the reality is that there's long delays in these processes. In fact, the ALJ hasn't even issued his decision yet. I mean, the hearing ended last September. There's long delays in these processes, and as you all know, if you're trying to conclude a deal, especially a merger, you can't sit on this deal for 9 months, a year. In fact, this deal is now, the merger was announced over a year ago, very early in 2020. So, and of course, FTC was largely, hopefully, banking on part of this process. And in fact, the Illumina case is a little bit of an odd example because Illumina basically went ahead with the merger. They said, we're not going to wait. So they actually merged, and so they're going to force the FTC in its ruling, which I think it's a safe bet. The FTC ALJ is going to hold that the merger forecloses the market. That they're going to have to unwind the deal. But if they hadn't, gone ahead with their merger, they probably would have just completely sidelined it at this point. Now, I have to say, one of the biggest concerns with this case is that it's not really just about this case. Because, as I mentioned, this what Illumina was doing was replicating what has been the dominant business model in the biotech sector for, as I mentioned, 30 years or more. And so what this case will establish is just a pall over all future mergers and licensing activities between small startup firms and the larger companies that achieve efficiencies, well-established efficiencies of these types of mergers, in deploying new products and services in the healthcare market, given the very high risk upfront ex-ante investments, on average estimated to be between around $2.6 billion before a single pill is sold to a customer in the marketplace, that is spent over at least a period of 10 or 15 years. So, and in fact, what's happening here, for anyone who has kind of been worked at the intersection of antitrust and IP, knows that this is not an unusual instance either. Antitrust has long had a problem with intellectual property, going, all the way back to Thomas Edison's restrictions on his patented technologies and movie cameras, and his phonographs, to the Alcoa case, where Alcoa, underlying that case is Alcoa, was the company was founded on the patented technology producing aluminum, and that's what gave them their kind of initial competitive advantage, and that's why they had the market dominance that they ultimately had. To the IBM case, that 13-year odyssey, to a favorite case of mine, Digidyne versus Data General Corp from the Ninth Circuit in 1984, where the Ninth Circuit confidently declared that Data General Corp had a monopoly in the RDOS operating system, that it was tying to its software programs that were being sold to use with it. You all remember suffering under the Data General Corp's monopoly with RDOS in the 1980s, I'm certain of it. So, to the 9 no-nos, right, from the DOJ on patent licensing, to patent pools, which were essentially per se legal until 1995, when the DOJ shifted to a rule of reason analysis. So, it's just that the antitrust has always had this problem. And it's shifted to per se rules, in part, I think, because you're talking about when you're talking about patents and copyrights and other intellectual property assets, you're talking about dynamic efficiency, you're talking about innovation, you're talking about the creation of new markets and new ways of doing business that can sometimes that on their surface can look like a monopolist or a market abuse, and can be characterized as such, and always has been characterized as such, even from the early 19th century, before the antitrust laws came into existence. And the problem is that even under rule of reason analysis, you need data. You need the economic data to assess whether this is actually efficiency enhancing or not. But if it's a new innovative market structure, like the franchise business model, or or other type of licensing deals, like the way that Qualcomm structures its business model, there is no data on it because it's new, and it's not because that's the whole point, that it's an innovation market, and so they end up having to default back to presumptions and what are essentially either explicit or de facto per se rules that just essentially have reflected what antitrust has viewed from the very get-go, which is that intellectual property is a monopoly and it should be treated accordingly under the antitrust laws. And I don't think that this tension is ever going to be resolvable. So, and on that happy note, I turn it over back to you, Ron. And again, I apologize if I did not sound very clear. Blame it on COVID. COVID caused our supply chain problems and my incoherence today.
No, you were very clear. It was very interesting to also take this example of Illumina and Grail as a surprising, if not shocking, example of how education can take place within agencies and the broader question of separation of powers, like what's the role of the courts at the end of the day if the judiciary system is within an agency. So it was very interesting. Also, in the Illumina Grail case, I think that the FTC at the end of the day, they suspended and wait for the European Commission to also decide on the same case. So it also raises the issue of international corporations, right?
Well, or gamemanship. So, really what the FTC was doing there was they're offshoring. So the FTC lobbied and convinced the EU to start its own investigation. So then the FTC, as a way to try to convince Illumina not to go forward with the deal, because by the summer, their game plan was, the summer of last year, their game plan was, we want to make it clear to the Illumina that it's going to be years potentially before this is resolved. And no company, if they're going to wait, is going to wait that long.
That's interesting. And also, even if the merger goes ahead, as you said, they may be subject to these letters of close at your own perils, meaning that they may even merge, but in some years, you may be subject to some unwinding of the mergers by a very more aggressive FTC. So there's a lot of legal unpredictability, and in that respect, that ties back to the rule of law, or at least the quality of law and regulations. So perhaps, Julie, you want to step in?
Yeah, I actually had one question, but now because of something you said, I have two questions. So the first one is, which I think is probably the easier of the two, is, to what extent do you think sort of drawing the Europeans in is a way to just sort of draw out the clock a little bit, right? Because they have a different sort of timetable, and, if there's some uncertainty about what you want to do in a case, or if you want to make mergers hard to accomplish, right, making the process longer in the United States by involving Europe, it seems like one way to do that. It's more of a comment than a question. But for my question, I'm just wondering, so you've sort of laid out this history of sort of how antagonistic antitrust has been towards intellectual property. And there's these IP licensing guidelines that Justice and FTC have that were, recently revised, right? But in those, they very affirmatively state, we treat the licensing of sort of intellectual property. We treat intellectual property as property, just like physical property, and antitrust applies. That there aren't any special rules because it's intellectual property. So I'm just sort of curious, like, this is a little bit crystal balling, but like, sort of what do you foresee for, like, they're revising the merger guidelines, they pulled the vertical guidelines. What do you think there's much hope for a future for those IP licensing guidelines?
I don't. It's a great question, and I don't. I'm very pessimistic about the future on this issue. The rumor is that the FTC is considering formal rulemaking on the licensing of standard essential patents. Which is an area where there's been a lot of agitation, to use a polite word, about concerns, and and Richard and I and many others have been writing on this and engaging with this, where this is an area where there's a lot of modeling and theories. But when you actually look at the actual the market and what's happening in the market, so the hold-up theory was promulgated in 2007 by Carl Shapiro and Mark Lemley, which on a model that predicted 30% royalty rates for standard essential patents. And so then the next 10 or 15 years, people spent time looking at the market and finding out, well, does that predicted royalty rate match what the market rate is for standard essential patents? You know what the actual real world royalty rate is for standard essential patents? It's 3.5% on average. So I mean, there's some higher end stuff, but on average, I mean, so and there are other things that people had already pointed out about the problem with the model from the get-to too, like they didn't take into account the fact that all of these actors are repeat players. and standard development organizations. I'm a member of both ANSI and IEEE. Function on cooperation, transparency, and a cooperative process. And so, if you engage in bad behavior, you get punished. People refuse to deal with you, and people refuse to continue to negotiate with you, not because there's a rule against it, just because people don't trust you anymore. And this has happened to this has happened to companies like Rambus and others.
Yeah, I mean, there's also like not a clear distinction between who are the licensors and who are the licensees, right? Like very often people have their own patents to bring to the table, which drive down the licensing rates as well.
Yes. So while Apple was, and that's true of the entire high-tech sector. It's massive cross-licensing and, it's an incredibly complex market structure. A point I often like to make to my students when I'm in patent law is that, when Apple sued Samsung for infringement of all of their patents on the iPhone, Samsung was continuing to provide Gorilla Glass to the iPhone. So Samsung is a supplier to Apple while Samsung was being sued for infringing Apple's patents, and that business relationship continued through the lawsuit.
Richard?
Yeah, I just as a thing, I had to miss the first part of this session, and there was a discussion which had Eric Hovind-Cam, Doug Malabid, myself, and Scott Keefe. And the central claim that I heard was that the inefficiencies of injunctive relief with respect to set patents is still the major problem, notwithstanding the fact that I think it's true, A, that these standards organizations are often competitive one to another, right? Which means that it's not as though they're monopolies in their own particular field. And B, I pointed out to the stuff that, Haber and Galactovich wrote. The basic point I made is this thing is going down at a rate that nobody expected, to which though Malamed replied was it would have gone down even faster.
Yeah.
And so I make the following observations. If I see a rock falling and it's like this, I do not say that's the area where I want to really investigate. But the basic rule for FTC investigations, and I think this is something I'd say to Scott, is I want to see some calamitous shipwreck before I start to put major changes in there. But anyhow, one of the things you didn't mention, and there's only a minute left or so, I'm going to mention it, and this has to go, I think, to also in comment to Scott. The central argument in this particular case was one about foreclosure, right? Mm-hmm. And it turned out there are two kinds of developments. One is you don't see a clear theoretical development, at least I don't see one, as to why it is that a firm is going to make money by refusing to sell to other people on the grounds that it can now sell to itself. If it turns out there are any gains from trade, they should be able to capture them and remain in the market. So it seems to me, just on a kind of simple Coasian kind of version, people don't give up customers really easily, because foreclosure is a remedy that you have to hurt yourself dollar for any supposed harm that you can inflict on anybody else, right? And secondly, the pattern in the FTC area, in this area, is starting with, I think, stuff that was innovated by Cravath early on, is what you do is you have in the particular provision notions that you will not hold out, that you will always agree to arbitration with respect to what's going on. Now, why would you do this? Well, first of all, if you're always going to do it anyhow, it doesn't really hurt yourself to bind it in terms of relations with other parties. But secondly, what it does is it starts to weaken the antitrust case by removing a major obstacle. So when the statement that I prepared, which Adam actually has it, knows what to do with it better than I, one of the things that the FTC said is it had to figure out how novel technologies require to strengthen enforcement. I said, look, novel technologies and contractual innovations may run in both directions. They may, in fact, reduce antitrust risks rather than to increase them. And I think that's right, Julie, isn't it? And so what you have to do is you have to ask whether or not, when you're doing this thing, whether we need less antitrust enforcement because we have more market innovation of what's going on. Now, we're just about over on the time, but you can't disagree with me, Adam, because it would be a case of treason, right? And disloyalty. But I do think, in effect, that's exactly one of the things that I deal with Scott and her paper, is I don't see any systematic position that the FTC has taken, which explains why foreclosure is a serious market risk.
Yeah.
I think we're done.
That's a very ending notes on the Adam's presentations. It was great. Adam, just get a rest. And thank you so much for your presentation.
Thank
was
you.
very clear.
You're all too kind. I'm
You're
gonna stick around. This has been fun. I'm gonna stick around for a few minutes potentially before I take a break.